Dear learners, welcome back to our channel Educare Horizon. Today, in this video, we are going to discuss the Code of Criminal Procedures Code 1973. So in this video, we are going to discuss short title, Extent and Commencement. What is bailable offense, non-bailable offense, cognizable and non-cognizable offense. This act may be called the Code of Criminal Procedure 1973. It extends to the whole of India. It shall come into force on the first day of April 1974. Then we are going to discuss what is bailable offense. Section 2, subsection A. According to this section, bailable offense means an offense which is shown as bailable in the first schedule or which is made bailable by any other law for the time being in force, and non-bailable offense means any other offense. So as per section 2 subsection A, bailable offense means those offenses which are shown as bailable offense in the first schedule of the Criminal Procedure Code 1973. Bailable offenses are not serious offenses. The accused person can ask for bail as a matter of right. The magistrate is bound to release the accused on bail. So, bailable offenses are not serious in nature, and as a matter of right, the accused can plead bail in front of the court, and the magistrate is in a position to release him on bail. An accused person is released on bail from the custody of officers of the law on furnishing satisfactory sureties for his appearance in court. In bailable offenses, the bail is granted as a matter of routine, either by the police officer in charge of the accused or the court. So, in the case of bailable offenses, the accused person is released by providing sureties and assurance that appearance in court. The next one we are going to discuss what is non-bailable offense. Non-bailable offenses includes all offenses other than the bailable offenses provided in the first schedule. So these are serious offenses like murder, rape, etc. The magistrate has got discretion either to grant or refuse bail. So non-bailable offenses are serious offenses, and the magistrate can decide, it is his discretion whether to grant bail or not. So these are, non-bailable offenses are serious in nature like murder, rape, etc. If the accused is below the age of 18 years, or a woman or a sick person, bail may be given by the magistrate. For offenses punishable with death or imprisonment for life, bail is generally refused. So in the case of a minor or a woman or sick person, the magistrate may allow bail. For offenses punishable with death or imprisonment for life, generally bail is refused. However, in the course of trial, if the accused is found to be not guilty, then he can immediately released on bail. No need to wait for the judgment, the pronouncement of the judgment. So in the case on the course of trial, if the court found that the accused is not guilty, then immediately, without any delay, see that accused may be released on bail, even without pronouncement. No need to wait for the pronouncement of judgment. As per section 437, the High Court and Session Court are getting wider powers to grant bail to an accused person in non-bailable offenses. So these are the provisions regarding non-bailable offenses. The next one we are going to discuss what is cognizable offense. Section 2, subsection C. Cognizable offense means an offense for which, and cognizable case means a case in which a police officer may, in accordance with the first schedule or under any other law for the time being in force, arrest without warrant. So cognizable offense means which are serious in nature, and the police officer is in a position to arrest him without a warrant from a court. So it means an offense for which, and a cognizable case means a case in which a police officer may, in accordance with the first schedule or under any law for the time being in force, in a position to arrest without any warrant. Cognizable offenses means offenses for which the accused can be arrested without any warrant from any court of law. The Schedule 1 of the Criminal Procedure Code provide the list of cognizable offenses. It is very important to arrest the accused persons immediately after committing the offense, and the police cannot wait for written permission from a magistrate, because the accused usually runs away and hides himself and may try to tamper with the evidence. So it is very important in some cases, serious offenses, it is very important for a police officer to arrest the accused without any delay. So he can't wait for a written permission from the magistrate. So he is in a position to arrest with immediate effect. Otherwise, the accused may run away from the site or hide himself or may try to tamper the evidence. So that is why, see, in cognizable offenses, the police officer is in a position to arrest him without any warrant. A police officer must prevent the commission of such cognizable offenses like murder. So he can arrest the accused even before the commission of such cognizable offense. The same way, the police officers must prevent damage to public property by way of arresting persons. So in some cases, some exceptional cases, the police officer is in a position to arrest a person before committing the crime like murder. So with an intention to prevent such kind of serious offenses like murder or damage of public property, a police officer is in a position to arrest the accused even before committing the crime. The next one, we are going to discuss what is non-cognizable offense. So cognizable offense means an offense a public of police officer is in a position to arrest him without any warrant, without any written permission from the magistrate. See, non-cognizable, in the case of non-cognizable offense, it is an offense wherein a police officer cannot arrest the accused without a warrant. So in the case of non-cognizable offense, the police officer is not in a position to arrest the accused without the prior sanction or without the written permission from the magistrate called warrant. In a non-cognizable offense, a police officer must get an order from the magistrate for the arrest of the accused as per section 155 of the Criminal Procedure Code. So in order to arrest in the case of non-cognizable offense, the police is required to get a warrant as per section 155 of the Criminal Procedure Code. The offenses are minor and less serious. So the society is not harmed much. So in the case of non-cognizable offenses, the offenses maybe it is generally minor in nature or less serious to the less serious or harmful to the society. Sometimes very serious crimes are also treated as non-cognizable, and very small and minor offenses are treated as cognizable. For example, a member of an unlawful assembly commits only a minor offense. However, it is treated as a cognizable offense, and the accused is arrested without warrant. So in some cases, even very small cases or minor offenses are also treated as cognizable, and the serious crimes are treated as non-cognizable. For example, in the case of a member of an unlawful assembly commits a minor offense, it is treated as cognizable offense, and the police officer is in a position to arrest him without a warrant. So these are the discussions about bailable offense, what is bailable and what is non-bailable offense. And also we discussed what is cognizable and non-cognizable offense. Thank you.